This podcast discusses sexual violence and other material listeners may find distressing. Please look after yourself as you listen and feel free to switch off at any point. You can visit withyouwecan.org to find help, but remember to call 000 in emergencies. We're recording on the lands of the Gadigal, where sovereignty was never ceded. We recognise that Aboriginal and Torres Strait Islander peoples continue to experience the ongoing impacts of colonisation, including disproportionate rates of sexual violence and institutional harm. We pay our respects to elders past and present and commit to advocacy that does not replicate the harms it seeks to address. Always was, always will be, Aboriginal land. Victim survivors live in a constant state of the unknown. I know that because I've lived it. Shrouded in secrecy, silenced by process, we're asked to place our faith in a justice system that was never designed for us, at the most vulnerable moment of our lives. But I won't stand for it. We're cracking this system wide open so you and everyone around you understands what it actually means to navigate the legal system after sexual violence. I'm Sarah Rosenberg, Executive Director of With You We Can, and this is what no one told us. On this episode, I'm joined by Eleanor Danks. Eleanor is a lawyer, somatic psychotherapist, TEDx speaker, facilitator, and expert by lived experience in the area of intimate partner sexual violence and complex trauma. As a lawyer, Eleanor has experience in the refugee sector, community legal centres, with First Nations communities, and in the criminal justice system. However, it was her experience of going through the system as a survivor herself, at the same time as working at the Victorian Office of Public Prosecutions, that solidified her belief that our criminal system is letting down not only survivors, but offenders and the community as a whole. Eleanor now works in one of the Australia First pilot programs offering independent socio-legal assistance to victim survivors of sexual violence across Western Australia, where she walks alongside victim survivors as they move through the criminal system. Her work in all realms is centred in principles of trauma-informed care, collectivism and regenerative and transformative justice, and the belief that with the right tools we can radically change how our society deals with harm at all levels. Eleanor, I'm so lucky to have you next to me today, all the way from Perth.
Thanks for having me.
You have a triple threat perspective on the legal system. It's incredible. It's not incredible how you got those perspectives, but I'm excited for today's conversation. You were at law school when you were experiencing intimate partner sexual abuse. Whatever you're comfortable sharing, can you tell us a little bit about it?
Yeah, I can. So I was in law school. I was in postgrad law school. And I experienced intimate partner sexual violence over the course of 9 months-ish, roughly. I'd prefer not to go into like intimate details, but the key thing that I always really like to speak to is that none of the violence that I experienced was what we think of when we say the word violence. I like to point out it still is violent. Sexual violence is violence, whatever it looks like, but there was no physical violence in the way that most people kind of picture these things happening. It was a lot of coercion and manipulation over the course of the relationship, but also the friendship that happened in the year and a half before the relationship started. That looking back now, I can really see how that manipulation and coercion was already happening at that stage, and how this person did that in most of their female friendships as well. And throughout the relationship, how it happened was that anytime I said no to sexual activity, something would happen. And it started out small. It started out as the first instance was that we were having sex and I changed my mind. I said I don't want to continue, and that was fine. He respected that, but he then proceeded to masturbate and finish himself off next to me despite me saying, can you not do that? And I only acknowledged that first instance as being the first instance of a form of sexual violence probably like 5 or 6 years later.
Which is so common.
Yeah.
Right? People don't people aren't educated about the extent of
Yeah.
sexual violence, but also people, when it comes to someone you know and someone, you know, you think you love or you do love, you don't want to think that these things are happening. And that's a completely normal and really common response, right?
Yeah, yeah, absolutely. I think one of the things that I experienced in the aftermath of it was I had a number of female friends who I had a lot of experiences of people not believing me, and either not believing me or thinking that I was exaggerating the extent of what happened. And I had a couple of friends, in particular female friends, who, it kind of got to the point where I felt like I needed to tell them very intimate details about each of the incidents. And, the sexual violence escalated to a point that he did rape me, and multiple times. And those details aren't something that you actually want to share with your friends and family in terms of like a blow by blow, this happened, then this happened, then this happened. And I had a number of friendships where I felt that that was the only way to get them to understand what I meant when I said he was abusive.
It's like you had to prove yourself with those gory details.
Yeah. And I had a couple of experiences with female friends where once I shared those experiences, particularly with those, not so much the final incidences, but all of those little incidences that led to those and set the scene for those final incidents, that they said, oh, but like my boyfriend's done that. And I had to kind of sit with them and be like, and that's not consensual. And, you can do with that what you like. Like, I'm not here to tell you that, you're being abused, or I'm not here to tell you what to make of your own experience. But I am here to tell you that just because you're experiencing that too doesn't mean that what happened was not abuse and was not non-consensual. And that's something that you actually need to sit with. And I'm really sorry that that's happening to you. But that doesn't mean that what I'm explaining is not assault and isn't rape.
What were their responses when you would try and shed light on the fact that, so many of us are experiencing things that we don't consider as coercive or abusive because they're not outright violent?
Yeah. They found it really hard. And I think that was an overwhelming experience of a lot of the people who genuinely cared for me, and also found the entire situation very hard to understand and to come to terms with because of their own cognitive dissonance, whether it be those women, or whether it be, other women and other men who couldn't pair what I was saying with their experience of this person, and found it, like there are a few people that it genuinely destroyed them for a couple of years trying to navigate that. And I actually hold a lot of compassion for them, even though that resulted in a lot of further trauma and a lot of further hurt for me. And, a lot of those friendships have completely ended because of that. But I hold a lot of compassion for them because I understand psychology and cognitive dissonance, and I could see how hard the struggle really was. Coming back to those women, I think some of them really let that in when we had those conversations, and it really was a big moment of inner reorganization for them. And others, they weren't ready for that, and couldn't do that process for themselves, and so said either, no, I think you're full of shit, or, tried to make me hold them through that process, which also is not okay. That's not my job. Go see a therapist or talk to a different friend.
God, that cognitive dissonance is such a killer. Like on a personal level, when you're realizing, when you're learning about experiences of abuse and realizing that they look like your own experiences, like that's one thing, but and that's a tough thing. And that bigger picture societal piece around needing cognitive dissonance, needing to distance ourselves from abuse and violence so that we can be comfortable to, you know, keep going on about our lives, it's such a killer to shatter. And it's, you know, what I often think is the first piece of the puzzle to getting people to understand and engage with the extent of sexual violence. Yeah. Like, perpetrators aren't monsters that jump out at us from bushes at night, and rape is most commonly not violent and doesn't involve kicking and screaming and resistance, and most victims respond with a similar matching of violence, which usually looks like verbal resistance, if any at all. And people need to be able to other themselves, because if it wasn't the victim's fault because of something you were doing or something you were wearing, then maybe it could happen to any one of us. Like, any one of us could be at risk, and that is the reality. But God, it's so hard to get through, because ignorance is bliss. It's not useful, but it's such an uphill battle, like from the very start, to be believed. And it's because people don't want to believe you. Yeah. Like,
because it's painful. And I think that's where, like, my compassion comes in, because it is like the experience of cognitive dissonance, like, yes, sometimes feels for the person who's in it like just complete, like, you know, that's obviously wrong and
there's no way,
you know, whatever. But the process of dismantling cognitive dissonance in any circumstance, but particularly when that dissonance is around behaviour that, you know, on the face of it, I think most people in society accept is horrific, is so painful. The idea of coming to terms with, you know, this is a number of people who were kind of involved in the aftermath of this when I spoke out about it were people who were equally friends with both of us, arguably people who were actually his friends who I'd met and then I'd formed a really close friendship with. And for them, like, he was everything to his friends. Like, all of his friends were family to him. He was joyful, and it's like there were reasons I fell in love with the guy, right? And those reasons were all felt by his friends. And to then be faced with information that in our mind can't go with those traits. Like, the monster myth is, you know, people who, like, men who rape women are these monsters in dark alleys who sit there at night fantasizing about raping women. And yes, those offenders do exist. They're horrible and they're evil, but the vast majority of sexual offenders or FTV offenders are not that. And so to bring together the idea of this person who has so many wonderful traits with them and has been so core to my well-being and my joy in life as their friend, and then putting that together with they're capable of something as horrific and as violent as raping someone, particularly someone that they claim to love, that's painful. And, like, you have to have compassion for that whilst also being like, sort that shit out.
Yeah, like, that is not okay.
Be willing to sit with the pain, because, like, that's the only way that we're going to change anything, is understanding that men we love and who have, you know, wonderful things about them are also capable of doing absolutely horrible things. Those two truths coexist, and we have to build the capacity to actually understand and hold that.
if people who use violence were easy to spot, we wouldn't be here in this epidemic that we're in.
Yeah.
I want to ask you something that you don't have to answer, but you've touched on it a little bit. How do you reconcile what you experienced at the hands of someone you were in love with? How do you reconcile that now? When you look back, do you disregard the entire relationship because of the violence you experienced for such a long time and that continued to escalate? Or do you still feel any kind of love for that person?
It's really hard, and it's something that
Does it change?
It changes constantly.
That's what I imagine.
Something that I think of particularly with, the advocacy work that I do, the fact that I am someone who has a, online presence and speaks about various different things online. Something that happened throughout the course of our relationship and friendship was that he noticed that I never posted pictures of myself online. And at that stage, I just had a personal Instagram page, the same as everyone else. Used all the coolest filters at the time.
Lux.
And he noticed
Paris.
that I never posted photos of myself, and he was the first person to ever sit with me and say, like, I think that's because you don't think very highly of yourself, and I don't, like, that's not okay with me. Like, I want you to think highly of yourself. I think you're beautiful, and I want you to be confident in yourself. And so he was actually like a really key piece in me becoming more confident. I have a history of complex trauma before him, and so he was actually really good at helping me with some of that. During our relationship was when I first started my more public facing social media, and I started in mental health advocacy. I have a lived experience of what I then was called treatment-resistant depression and anxiety. And epilepsy, and I did a lot of mental health advocacy in organisations and stuff, and he was the person who helped me actually start speaking online and sharing the knowledge and understanding and passion that I had with an audience. And so I don't know if I would be, well, in one way I definitely wouldn't be in this chair today because he wouldn't have raped me, but I also don't know. You've got to laugh or you'll cry, right?
Got to laugh or we'll cry.
I don't know if I'd be here being able to be a public figure in that way and speak publicly and advocate and have the confidence in my advocacy in the way that I do without him, which is such a weird thing to reconcile with what he did.
It doesn't mean you're saying I needed to experience sexual abuse
to
be confident. It just means there were parts
of him, which are the parts that his friends and everyone saw that they found it hard to reconcile. Those parts exist, and they're not a lot of those parts. There were definitely parts of those parts that I look back now and I'm like, no, actually he's manipulating you all. Yeah. And he is very aware of his social
talent to do that.
Talent and his decisions, and he is very conscious of decisions that he makes. And also, I do think that he gives a shit about people in his life. I do think that, there are parts of him that are good, that are genuinely that thing, that aren't there for the purpose of something else.
And the key word is and.
Yeah, and. he's also capable of doing the things that I said he did.
You were working at the Victorian Office of Public Prosecutions when you decided to report. Tell me about that.
Yeah, so I was a lawyer at the Victorian Office of Public Prosecutions, or the OPP. It was my first full-blown lawyer job after, becoming fully accredited as a lawyer, I guess. My experience before that was a lot of stuff in human rights law and refugee law, and then a little bit in defence. Both,
I dabbled.
Both in, internships in legal aid in my final couple of years of law school, as well as I went up and worked with Indigenous people in Alice Springs in defence. And then I got the job at the OPP. So I worked as a lawyer for them, which means that I essentially ran prosecution matters. I mainly did things like drug trafficking, aggravated burglaries, home invasions, that kind of thing. I did not do sex offences because of my lived experience, that I decided that I wasn't ready to do that. And when my experience of sexual abuse happened in my, primarily in my second last year of law school, I decided at the time, a number of people were like, report to police, that's the thing to do. And I looked at it and I said, I don't think it'll go anywhere. I don't have any evidence of it. I don't think that they'll believe me. Funnily enough, I was very aware of I don't think this is going to work, so I don't want to do it. I was also already a huge lover of restorative justice.
Yeah.
And I didn't want him to go to prison. Yeah.
Which is kind of funny to think about how rare it is that happens. But so many of us have that thought.
Yeah.
Yeah.
Yeah. So I decided not to report. And then when I worked at the OPP, even though I wasn't running sex matters myself, I shadowed on a lot so that I was still learning about them. And I kind of realised I actually do think that I have a case here. And I think a lot of that came down to realising that my evidence was evidence, which I think, and is still something that drives me absolutely nuts to this day, when people they say, oh, but there's no evidence of this. A complainant's statement is evidence, and in every single state and territory in Australia, a jury is allowed to convict beyond reasonable doubt on the evidence of a complainant alone, without any other corroborating evidence. So the correct term is, there's no corroborating evidence. There is evidence. You have a victim who is telling you what happened to them. So I realised that was a thing, and I had, some message conversations that I'd had with him after, kind of, I guess, the relationship ended. And suddenly I was like, I actually think I've got enough here. So I decided to report. I also, not consciously at the time, but looking back now, I can very clearly see that, my experience after the abuse happened in telling people in my life was that I was not believed. And I unconsciously thought that because I was a prosecutor, that I would be believed, because I'm a prosecutor. I have incredibly high ethical standards. If I maliciously reported someone for rape, I would lose my legal license. Why would you not believe a prosecutor when she says that she's been raped? And I think that really gave me the confidence to go ahead.
You also like know in and out the law, and you're learning about sexual assault procedure, and you know what's what more than most other victims do. Like, so few of us have any understanding of the law at all and what is required, and it's like through and through exactly like the roadmap that may be followed and what is required for you to start that process. So
absolutely.
It's like,
and I think that's something that I've always been really keenly aware of, even when the abuse happened, that I like I said, there were lots of things in this relationship that I now understand were sexual violence and were assault and were coercion and manipulation and all these things, that it took me a very long time. It took me over a year to even refer to the rapes themselves as rape. For a long time, I called them assaults. And I still, to this day, remember the therapy session that I had when suddenly I called it a rape, and she just looked at me and she was like, thank fuck we're there. Like, well done. With an abundance of love and compassion. Of course. But it took me a really long time. But the only way that I could do that and get to that point was the law. So I had a printout of the criminal code sections for assault and rape, and they were folded up and they were in my bedside table. And every time I would get into this head spin of saying, all these people are right, I'm just exaggerating, I'm being a drama queen, I'm hysterical, I'm just upset that he doesn't want to be with me anymore, I would get out this legislation and I would go, okay, these are the elements, done, 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 done. I'm not making this up. Like, I'm not being dramatic here, because I trust at the time, you're one of the only I trust people in the law, and I trust that in criminal law the standard for sexual assault is actually quite high. Like, there's a lot of things that societally and behaviourally we understand and still refer to as sexual violence and sexual harm, and even domestic violence. Coercive control is a huge one. Coercive control in WA, where I live, is still not a crime. We still understand that coercive control is wrong and is abusive. The level to which violence has to get to in order to be considered a criminal offence is actually quite high. And so I could look at that and be like, I meet that high criteria. Like, yes, something bad happened to me. And I've always been so conscious of the fact of, I found the process of recognising the abuse, the process of speaking out about the abuse, the process of reporting and going through the criminal justice system, of doing a compensation claim after the fact. I found it all so, so hard and was so confused the entire time. And I had a fucking postgrad law degree and I worked as a prosecutor. So what do the people who don't have those things and don't have that knowledge and education and training, like, imagine how they feel. Not
having legal literacy, really.
Yeah.
I mean, that's what I've been
exactly
calling it. Everyone else is finding their way through at the most vulnerable moment of their lives.
Yeah.
And they're just blindsided. It's not something we learn about. My God, you're one of the only people, I think, who has ever said that they were comforted by the law. I'm glad you were. At what point did you realise the system wasn't operating in accordance with its own guidelines?
Pretty bloody soon. So after I reported, and I'll try and, hit these points quickly, my initial report was great. The detective was kind, compassionate, believed me, all of that stuff.
Wonderful.
I was then told to write my own statement with no police assistance. She said, go home, write your own statement, send it to me when it's ready. And I said to her, and, you know, I've actually been through the criminal system twice as a victim. The second time was last year, a wildly different experience. And the reason I mention that is because the detective on that matter, I said the same thing to both of these detectives, both pretty young female detectives from the sex assault squads in 2 different states. And I said to them, I'm a lawyer, and, you know, either the first one, I'm a prosecutor. The second one, I work as a lawyer for victim survivors of sexual violence. Please do not treat me like I'm a lawyer. I want you to treat me like any other person. Do not assume that I understand what's happening. I don't feel like my legal brain has turned to mush. I want you to treat me as if I know nothing. The second experience, she did that. At every single point through the entire process, she did that, even to the point that she'd reiterate it to me and say, I feel like an idiot explaining this to you, but you've asked me to. And I'd be like, thank you, explain. And the first one, just, I don't know if, I can't speak to her inner thoughts, but she didn't do that at all. So she told me to go home, write my own statement by myself, to send it to her when it was finished, and I could come in and sign it with her. And that statement was I think something like 25 pages long. It included everything under the sun about our relationship, even some things about our friendship before the relationship. It included so much shit that would never be admissible or never even be relevant for a trial, but that I felt
Gave context, or was, you know, a lot of it was me explaining weird things that I did. The fact that I didn't, when I confronted him about it at the end of the relationship, I didn't call it rape. And I needed to I needed to explain why I did that. So there was all this surrounding context that I know as a lawyer would never get into a trial, but as a complainant, I didn't know how else to give a statement. And because I made the statement by myself, that was all in, which meant that defence got all of it, which basically meant I handed defence their defence. Literally.
And, you know, so that was the first thing. The next thing that came out was that the detective had written incorrect notes in her police notes. She'd written that I, on one of the nights of one of the final incidents, that I had taken GHB. I had not taken GHB. I have never taken GHB. I'm on epilepsy medication, which can make me sleepy and it means that I don't wake up very quickly or easily. And I don't know I don't know what the hell happened, but
GHB, epilepsy medication.
That came out.
Oh,
that was obviously a big
point of contention.
And police notes are disclosable. They go to defence. It then took 15 months for them to charge him. I'm thoroughly of the belief that he never would have been charged if I hadn't consistently nagged. In the end, a different detective took over the matter and said, you know, that detective's caseload is too heavy. I'm going to continue this so that we can get it done for you. Great.
Nice. You had an explanation.
Yeah. He then took a statement from one of my, the best mate of my ex, who was also, at the time of all the abuse, a very, very close friend of mine. And who I had explicitly told absolutely every detail of everything to about 6 months to a year after it all happened. Again, because he didn't believe me. So I sat him down and told him everything. And the detective took a statement from him. He lied and said that I'd never told him anything. And the detective came back to me and accused me of lying. He was awful. He said really, really awful things to me. I was sitting in my individual office at the OPP that is made of glass. So it's like your own office, but it's not private. And I was in hysterics, to the point that my trial division manager came into the office and was like, what is going on? Yeah.
Is that when you first disclosed to members of your workplace what was going on that you were reporting?
Yeah. So no one in my... Sorry, I had one colleague who knew because we had been friends prior to both of us working at the OPP, but no one else knew. I think maybe I had told like a kind of senior manager, like a couple of levels up from my role, that I had a lived experience of sexual violence because I wanted to be introduced to sex matters slowly. So I had told her that so that she understood and that could happen. But no one else knew. And then all of a sudden I'm sitting in what is essentially kind of an open plan office with a bunch of glass.
An aquarium. In
hysterics, yelling at a detective to stop cross-examining me. Which is, Anyway, he was charged 15 months after I reported. So the matter then goes to the OPP. The OPP wouldn't have been able to prosecute it if I had stayed, because it would have been a conflict of interest. So the Victorian Solicitor's Office would have prosecuted it. I had already been thinking about leaving. I wanted to go part-time and start doing some of my own stuff part-time and was not really coping very well. And then they told me that and I was like, I'll leave. Because in my body, I was like, I trust you. Like, I trust people in this office. And it just...
I hate that on top of everything you had to give up your job. And I know that's the least of things here.
Yeah.
But it's just I doubt anyone's there considering that toss up.
Yeah.
So it's
and
it's
I want
not
to be clear,
taken
like
lightly.
it was not it was completely my choice to leave. I wasn't told to leave, it wasn't suggested me to leave. I was purely told, because you work here, we can't prosecute it, so it will be another agency. And I said, absolutely not. You need to prosecute it because I trust you.
At that point, when you made the decision to leave, had it been implied that it would be prosecuted?
No, because it had been committed. So charges had been filed. Sorry, it hadn't been committed yet. The files had been charged and he'd had his first appearance. And then the brief was sent to the OPP. And at that point, they were saying, this can't be us while you work here. So they hadn't, at that stage, they'd probably had like a very brief look at what it was.
Brief.
But they hadn't made any kind of assessments yet. I then left. It was then, so the next stage is that it goes to a committal. In Victoria, defence can still call witnesses at committals, so I was going to give evidence at the committal. The committal was adjourned because of COVID and because all the magistrates' courts closed. But I was still working as a lawyer at this point, part-time in a community legal centre. I was aware that magistrates' courts were not running committals and I wasn't even working in defence. I was providing some general advice to people who had just been charged with stuff. And I knew that the magistrate court was not running committals that had in-person witnesses. So I contacted the OPP probably like 6 weeks in advance saying, hey, is this thing going to run? Like I'm I don't want to go into preparing to give evidence and reading through my statement and doing all of the emotionally taxing stuff that comes with that if it's not going to go ahead. And they were like, don't be silly. Of course it's going to go ahead. Why would it not go ahead? Blah, 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 blah. 3 days beforehand, it gets adjourned because the Magistrates Court isn't hearing committals. And it gets adjourned August to April the next year. So solid amount of time. The charges were discontinued 2 weeks before the second committal.
How many months is that?
15 months.
Quick maths.
Or 15 months, I think, after he was charged, which was 15 months after I reported. And the key thing that, like, court processes get delayed. Like, delays are normal. Like, the delays, it doesn't make me angry that it was adjourned. Like, I get all of that. It's shit. It's hard, but, like, it's kind of unavoidable and it's very common. The issue that I took was that the person prosecuting my matter was a very senior prosecutor. They'd done that to protect my privacy within the OPP, which obviously I was very appreciative of. And before I left the OPP, a policy was introduced because of the new victim or the updates to the Victims Charter. And we had really specific timelines as to when we had to contact victims by, how often we had to, update them and talk to them. And in particular, how soon after receiving a brief we had to do a full assessment of it. So part of what happens when you prosecute a matter is that you get the brief of evidence from the police. Police have decided based on their investigations that there is enough to charge, which is already a very, very high barrier or high level standard. And then the brief gets given to the OPP and it is our legal responsibility to do a fresh assessment and decide on our terms whether the standard of proof can still be met and whether there's a likely chance of success if the matter goes to trial. That requires you reading all of the evidence available to you and also deciding, is there any further investigation that actually needs to be happen, and we can direct police to do that further investigation. I know that the policy was that assessment should be done within 2 weeks of getting a brief. That's a pretty short time frame. That's okay if you don't make that time frame. The discontinuance was on the basis of evidence that I had voluntarily given to police the first day that I ever spoke to them. So before I'd even signed a statement, I gave them a copy of all our messages and all of this stuff. It was that evidence that was used or was the basis of the decision that a jury would likely not convict because they would likely decide that I was a jealous ex-girlfriend and was upset that he was sleeping with other people. And that evidence, whether I agree with that decision or not is to one side. That evidence had been in the custody of police and then prosecution for 30 months. What's that? 2.5 years. And that delay is something that is completely avoidable. And it has, I think, the thing that a huge issue with our current criminal system is that the focus is on the accused. The focus is on, it's a accused focused system because that's how it's been designed. And, rightly or wrongly, that's the way that it is. A victim is like not even second thought. A victim is the last thought. And, I once had a matter where, as in my current role, where something happened during the trial and the jury had to be dismissed. And part of the decision as to whether or not to dismiss the jury, because that then means that there's more delay, the trial's not going to happen the next day, the trial's going to happen in like a year from now again, is that the judge has to take the harm that the complainant will suffer because of that delay into account. And she said, well, you know, we've already got the victim's evidence, we've got that recording, so she won't have to come back, so there is no harm. If you cannot understand the fact that a victim is like sitting frozen in their trauma until that matter is finalised, that is harm. I said, you know, when my matter was discontinued, I said to the prosecutor, I have made the conscious decision to not go through trauma-specific therapy until I was finished giving evidence, because I know that, you know, prosecutors care about that. And we see that over and over again, that complainants decide to not go through things like EMDR, as an example, or any other trauma-specific therapy, not surgery.
Mine was the same with surgery. Kind of feels like that. EMDR kind of feels like being cut wide open. Yeah. I was the same, avoided EMDR. Yeah. And it was life-changing. It was what stopped my suicidality in its tracks, and I waited till after.
Yeah. And even the fact that, you know, if you have it in your mind that this matter is still going on, there is a level to which, like, what we naturally want to happen if we go through something hard from a therapeutic lens is that we want memories to integrate and kind of like just go into the background of our lived experience.
Yeah.
The issue with trauma is that that doesn't happen. We know that traumatic memories can be, the way that they're stored and the way that we re-experience them when we remember them is more like a present memory rather than a past memory, and that's partly why it's so horrible. The process of trauma therapy, or the process of just integrating trauma naturally in your own time as well, is that memory gets integrated in as a past memory. If you have an ongoing criminal matter in which you know, even if you've pre-recorded evidence and you've been told that you won't be recalled, there is always a chance that you will be recalled. And so in the back of your mind, you're like, I need to be able to remember this memory blow by blow. Otherwise, I'm going to be told the memory isn't enough, or is false or whatever. And so even if you have a client who's, you know, pre-recorded their evidence, you know, whatever, understanding that delay means that memory is, they're probably trying to actively relive that memory so that they can remember it for the purposes of that prosecution. And to not understand that delay causes real tangible harm, and not like just not avoids, like I always say, like there's no neutral when you're dealing with victims of trauma. You are either harming them or you are helping them heal. There's no neutral. You saying, well, I'm not consciously asking you to relive that. That's your own choice. That doesn't matter. They are reliving it because they want him to be convicted or them to be convicted.
Even aside from you trying to actively remember and keep, you know, your sort of what would be your testimony present in front of mind, even subconsciously, just because of the process you're going through, you're in a state of distress. Like you are scientifically...
And confusion.
Yeah, and you're in a state of survival. And so like separate to... I mean, I think the biggest thing is the fact that you're actively trying to keep it front of mind. But even if you weren't, you are in... It's not over until it's over. It's unforgivable. For like so much of this, so much of the problems are... like commonsensical, like they're stupid. They're inefficient and ridiculous and absurd, and you'd think anyone else could get it right, and then the people who are meant to be in charge of this stuff can't get it right. It's unforgivable.
So the much more common concern that complainants themselves often have, lawyers have, or prosecutors have, but also therapists have. We increasingly find that a lot of therapists have very strong views about this, is that because what I said about the way that traumatic memories are stored, and therefore when you re-experience them, you relive them as if you're reliving them in the present moment. And on the stand, that's probably we think that that's going to look like an appropriate amount of distress. EMDR specifically, and kind of trauma-specific therapies more broadly, aim to change that so that when you have a memory, it doesn't delete the memories. We cannot delete the memories that we have, and we don't want to. That's very unhealthy. But when the aim is that when a memory comes up, that it doesn't take over your system and you don't feel like you're back in it. It feels like this happened in the past and I am not overwhelmed or flooded by it. That's the goal. So when you are giving evidence, the concern is if someone's not actively being triggered by recalling the memory, that their level of emotional reaction is going to be somewhat less or different than it would have otherwise been, and that a jury is going to interpret that as this didn't happen. There are so many issues with that logic.
We're encouraging an avoidance of help seeking so that a victim can present in line with myths about what trauma looks like.
But also, yes, I completely agree. And also, those assumptions are completely incorrect.
Completely.
A victim, you might have one person who gets triggered on the stand and reacts with distress. You might have another who, gets a physical response and, gets some twitching or whatever. You might have another who has naturally completely disassociated from these memories, and therefore when they come up is all like doing EMDR might actually help them feel more emotion around the memory because they're in their body.
Rather than being numb or dissociated.
Yeah. So to work on the assumption that EMDR is going to make you have a less, appropriate reaction is in and of itself blatantly incorrect. But it also presumes that we can understand how a jury is going to interpret a victim. And the important thing to remember, which is the entire premise of having a jury in criminal trials, is that juries are made up of individual members representative of the community. So you can have a 60-year-old grandma who has gone through a life of trauma. You can have a 20-year-old guy who is a rapist himself. You can, these are broad generalizations and stereotypes. You can have, a 40-year-old, you don't know who's on the stand and what lived experience they have, and therefore you cannot in any way predict how they're going to respond to distress, dissociation, numbing out. Maybe they want a complainant. Maybe they feel like a complainant is more believable if they are able to rationally and coherently speak. We have had, I've seen prosecutors tell complainants who have very severe PTSD, and it's very clear while they're giving evidence, and it really affects their ability to give evidence. I've heard prosecutors say, I can't put you on the stand, you're too emotional. And then at the same time telling them you can't have EMDR until the trial's finished.
Yeah. For me, it was the decision to be in the room. Oh, great, that makes you... they can tangibly see you upset in the person. They can form a bond with you and a better opinion of you versus other people saying, well, if you were really traumatized, you would have to testify via video link because a real victim wouldn't be able to be in the room.
I was told that.
Yeah.
I said when the matter initially got to the OPP, I said because it's... complainants of sex matters are kind of technically in most states I think you still have to technically make the application for them to appear via video link, but it's kind of assumed to be just we do this for it's part of every sex matter and it's never going to be denied. I said to the prosecutor, I think I want to give evidence in court, and they said to me, well, I'd think about that because it may come across wrong. And again, a lot of my clients ask me what's going to be better for the jury? What's going to be better for the jury? What's going to be better for the jury? And first of all, I have to say, I can't coach you.
Yeah.
20 defense lawyers or prosecutors listening, I cannot coach you. But also, the thing that I say to them is, you cannot predict
It's
a
just
jury.
constant downstream.
And so the most important thing is for you to do what is most authentic for you.
Yeah.
Because in my opinion, authenticity is something that you can generally trust juries will be likely to pick up on.
Yeah, they resonate with
Yeah.
it. It's
And if he's not convicted, if you've put yourself in court because you think that they're going to, you know, believe you more if you're in the room or whatever, and then he's not convicted, what does that mean for you? So every choice that you make where you do get choices, the few instances where you do get a choice, make them in line with what's actually most authentic and most right for you and most empowering for you, because you don't, making decisions based on the outcome is dangerous.
Yeah, it's
because
not
the
helpful.
outcome is so rarely positive.
What about other kinds of therapy? Why might a victim be fearful about disclosing to practitioners their sexual assault before a trial?
It differs slightly between state to state, but generally speaking, every state and territory has a level of protection around what's called protected communications when it comes to sex offence matters or sexual violence in general. And what that means is that anything that is deemed to be kind of broadly come under the term of counselling by a trained professional is considered protected, and for each state there's a difference process that prosecution or defence have to go through in order to use any of those records as part of the trial. The reason those protections are in place is to essentially protect the right and need for victims to receive support and to be able to receive that support without the looming prospect of anything that they say to their counsellor being used against them in court or misconstrued or whatever it is.
So barristers try to access counselling communications.
Yeah, prosecution can too. There's really actually in every case that I've dealt with protected comms so far, it's actually been police that are wanting to access it. Because they think it will help. This person has disclosed
Evidence
the
of
violence,
disclosure.
and so it's corroborative evidence, and so they want to catch the bad guy, and so they want a record of that disclosure. But defence can do it too. So it's whether defence or prosecution, including police, want to be able to access those disclosures or those information as part of the trial. A really common, way that defence might want to use it, it's probably not so much in relation to the disclosure itself, but for example, if you have sexual violence that happened as part of a domestic violence relationship, so there's an ongoing relationship, and that other party, the accused, is aware of, that the complainant has a diagnosis of bipolar, or they have a history of psychosis, or they've said something in therapy maybe that has excused the behaviour of the accused and said, oh, it wasn't rape, it was something else or whatever,
or he didn't
and
mean
they
to.
have knowledge of that, they can tell their defence lawyer that, and then the defence lawyer is going to want to get that in order to use it against the complainant. The reason why we find that a lot of clients are really hesitant in going to therapy while there's an open criminal matter is because those protections in a lot of places aren't very well upheld. There's different responsibilities on different parties. It's hardest for defence to get it because defence would have to subpoena the material, and there's a awareness on behalf of clients, but also therapists, that you're going to use this in a bad way. When we usually see it, it's usually that police are wanting to obtain it in order to help the prosecution. But there's a process for a reason, and that evidence is not always necessary.
And I think the fact that they access it also makes it, it gets handed over in the brief, and that then is where barristers sort of get grounds to start combing through and looking for other information, or even using whatever information was well intended from prosecution. They start to twist that, and we know they twist it basically based on myths. You know, she was crazy, she's making it up. The harm that you now have disclosed that is a result of the violence is reason to believe that it never happened in the first place, or other more twisted
or you went to couples therapy with him, you obviously aren't scared of him.
Or other more archaic, more twisted things, like you have had an abortion in your past and that is sinful, or other absurd,
or you've experienced sexual violence in the past and therefore why should we believe that this one happened?
And you're confusing it with that time.
You misconstrued it. He didn't actually mean to ignore your lack of consent. It was just your trauma history. Or, you've now reported 3 offenders. What's that about? Where in fact we know research shows over and over again that once you've been a victim of sexual violence, you are far more at risk of being a victim again. And therefore it's this really twisted, it's used against a victim to mean that this time wasn't what they said it was, at the same time as us being aware of the research showing that it's actually the opposite.
When irrelevant, intrusive and myth-based questioning goes unchallenged, what does that do, not just emotionally to the complainant, but evidentially to the trial?
It hands jury reasonable doubt. If you, and this is, I have had kind of, students or social workers attend trials with me and watch how defence or particular defence lawyers carry out a trial, and they always come out and be like, that's so unethical, that's so harmful, blah, 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 blah. And I have to explain to them, firstly, I agree with you. I thoroughly believe that there is an ethical way to defend a sex matter, and an unethical way. But I also explain to them, at the end of the day, their job is to do whatever is available to them to get their client off. That's their job. That's what they're getting paid for. They don't represent the state. They don't have to be impartial or unbiased. They represent their client, who is inherently a very partial and biased person in this proceeding, and they're going to grab onto whatever they possibly can to get that reasonable doubt, that seed of doubt, into a juror's mind. The easiest way to do that in a lot of matters is relying on myths, because they are, the myth that, say, a rape happened, someone saw the victim, the rape happened at, a sleepover or whatever. Everyone's sleeping. You've gone out for a night as 20-year-olds. You've all slept at one person's house. A rape has happened in one of those bedrooms, and after the rape, the victim has come out of the bedroom to go to the bathroom or something, and so other people have seen her. Those other people get on the stand and they say she seemed totally fine. We didn't hear anything. She wasn't screaming. She wasn't crying. She, whatever. She seemed happy. That then is used by defence to say she wasn't acting how you would think a rape victim would act. That is a myth. There is no way that every rape victim acts in the immediacy after that rape or at any point into the future. So why are we relying on that to see that reasonable doubt? But because these myths exist in the societal and collective psyche, to a juror, that makes sense, because they haven't gone through the process of detangling their own cognitive biases and all these myths within themselves, because they're just an average Joe Blow on the street. So when they get this evidence of 3 people who saw her 10 minutes after this rape apparently happened saying she seemed fine, and you have a defence barrister who this is their job, and we're in a courtroom saying that means that she wasn't raped, and you have no one standing up and saying that's bullshit, And that shouldn't be allowed because there is no evidence to show that a rape victim will always be distressed in the immediacy after that offence. A jury goes, yeah, that kind of makes sense. And they don't want to put someone in prison.
Yeah. I say this all the time to people. If a jury hears in a court of law from a man in a wig and it goes unchallenged that she's a skank, so she asked for it, they're like, she's a skank, so she asked for it, and off they go out reinforcing that rape myth tenfold into the community. Yeah. And then we wonder why we have a culture of impunity.
Yeah. I always like to tell people this story that my father-in-law, bless him, thinks that I am like the president of the universe because I'm a lawyer. I just think like I could tell him that the sky was yellow and he'd be like, Ellie said it, it's right. And this one time we were all at their house and I was having this like, you know, very lighthearted but like passionate debate with my sister-in-law. And my father-in-law kind of piped up and was like, Sophie, stop arguing. She's a lawyer. She's right. And Sophie and I were both just like, we're not talking about the law. I can't remember what we were talking about,
like,
but it was nothing.
But I am right.
And I was like, Steve, and he's like, it's people, we are taught to trust authority, whether it's a doctor,
someone in a white coat,
Simon Gordon, or whether it's a lawyer or whoever it is. We're taught that the more qualifications you have and the more power that you're given, the more trustworthy you are and the more intelligent you are. And that is so, so unbelievably incorrect.
And it goes for types of defendants as well that we see.
Absolutely, yeah.
We know that the victim is unrepresented. Whose job is it to challenge these inappropriate questions, to challenge when legislation that's meant to protect, sensitive information like confidential counselling notes, whose job is it to enforce that protection? And before, you say no one, because we know that that's the answer. Why, if it's handing the jury reasonable doubt, why wouldn't prosecutors be interested in enforcing that legislation and challenging those questions or putting a stop to them?
So I want to rebut something that you just said when you said no one, because it is the prosecutor's job. If there is a legislated protection, whether that be a strict one like protected communications where there is a very laid out process that and tests that have to be followed, or whether it's sexual history questioning or whatever it is, or whether it's a more broader protection of, in order to question a witness, any witness on something, it has to be relevant to the matter. So that's a broad kind of way to object to a line of questioning. So whether you have a strict protection or a broader protection, it is the prosecutor's job to object.
What about the judge?
The judge, it is their job to decide. So the defence asks the questions, the prosecutor objects, and vice versa. Like defence, I can assure you, defence object all the time. But someone asks the question, the other party objects, and then the judge makes the decision. A judge can, they can definitely step in, and there will definitely be times where they kind of say, Madam Prosecutor, would you like to object to that? But they do like to, it can come across to a jury very strongly if a judge is the person to initiate an objection and to kind of say, don't ask that. You can see the concern of it looking straight away like they're on the side of the other party. So realistically, it really should be the prosecutor who objects and then the judge who makes the decision. And a lot goes wrong with both of those steps.
This brings us really nicely to that third perspective of the legal system I mentioned you have, working as an independent lawyer for victims as part of the WA pilot. Can you tell me about it? What are you seeing so far? What's it like? What's your role?
Yeah. So my role within the pilot is that I'm an independent lawyer for victim survivors of sexual violence. The pilot has been up and running in WA. It's one of 3 pilots across the country at the moment. There has been talk of funding for a pilot for every single state and territory, but they're not in place yet. So WA, Victoria and ACT have been running since seeing clients since around like middle of 2024. I came on in August 2024 and have been there ever since. And we provide what's called independent socio-legal assistance to victim survivors of sexual violence. So we are an integrated service. We have lawyers and we have social workers. There's no we call it a no wrong door policy of however you come into the service, whatever stage of the process you're at, you can access information and advice from us. And it's been created to, you know this very well, but for the audience listening, it's been created to hopefully provide a higher level of support and maybe one day protection, or definitely in some ways protection, to victims as they go through the criminal system. The reason why it's called socio-legal assistance is because technically in a criminal matter, a victim does not have legal standing. The one point that they often will, or in some states, they have legal standing to be heard in court, either by themselves or by a lawyer, is protected communications, like we just spoke about. But aside from that, they do not have legal standing. They're not a party to that proceeding. They're a witness in it. So in a lot of cases, the way that we work with clients might technically not be considered legal representation because they don't have standing. It's more legal information, legal advice in some circumstances, but also just being having someone whose focus is you. Walk beside, and who is legally educated and experienced, walk through the system with you. Prosecution's focus is not the victim, it is the accused. The judge is focused on the accused. The defence is absolutely focused on the accused. But also, you know, I said prosecution is focused on the accused, but also prosecution represents the state. And it is very, very important. I think that when we talk about sexual violence and probably FDV as well, when we look at the criminal justice system, we're like, someone needs to protect this victim more. It is really important to remember that the criminal legal system also lets down a lot of offenders, maybe not so much in sexual violence, but definitely in other types of crime, particularly if they are, you know, victims of oppression in any kind of way, which a lot of offenders accused are, that it's really important for prosecution to be unbiased and impartial and to represent the state. And they take that very seriously, which often, rightly or wrongly, can look like them not really caring about the victim or not really paying attention to the victim. So we come in, and my focus is I still have my duty to the court, I can't lie to the court or whatever, all of that. But my focus, my client, is the victim. And even that by itself, we know, after having been working with victims since middle of 2024, that is by far the piece that actually makes the most difference.
From your perspective as a former prosecutor and your experience as a complainant, where might independent legal advice or representation help or make a difference, other than when it comes to protected communications?
So I might start with my personal experience and then go to prosecution. You know, when I said earlier that the first massive thing that went wrong in my matter was that I was told to write my own statement, and I didn't write it from the perspective of a prosecutor. I wrote it from the perspective of a very traumatized and confused victim who was currently being told by every which way that she was being hysterical. And if I had had access to a lawyer at that point, I can't help a client write their statement. Yeah, they have to do that themselves. Well, police should be usually help them do it, but everything that a victim says has to come from them. I can't tell them what to and what not to say. But what I can do is help them understand that police are looking at offences. There is a lot of evidence that you will want to explain that won't actually ever be admissible at a trial. You can include it if you want, but do you want to include that if you know that it's not actually going to be able to be spoken about in court? And or even someone to ask, you know, should I give this thing to police or
like your
or
phone.
whatever? And yeah, like, I mean, the number of clients that come to me and say, oh, police are already contacting my counsellor. I told them to. And I'm like, quick on the phone, stop, halt, no. Because they don't know the ramifications of that, and they don't know that there's a process that really has to be followed and how that might go wrong for them. And that's the kind of stuff that I can help with. It's not about changing how they deal with police or changing what they do and don't say. It's about helping them understand the system so that they can make decisions themselves. I mean, the other huge thing that I do that I could have really used in my own matter is someone to advocate for me with those systems, someone to fight that police note that said I was on GHB at the time of the offending, someone to follow up with the DPP and be like, yo, what's happening?
Why are you taking
all of
so
that
long?
kind of stuff that is like, you know, that's not really legal work, but it's still, that's a huge part of what I do for clients, is that I liaise with those agencies on their behalf or with them.
I think the point though is that you have client privilege.
Yes.
Firstly, so you know none of the conversations with the victim can be accessed by defense or prosecution. And the other thing as well is that you have a level of respect, and just by virtue of being a lawyer, as in according to both other parties and judges as well. And I think you have legal understanding so that you can explain like the utter legal jargon that victims are expected to decipher on their own.
Yeah. And we definitely, like, overwhelmingly, that's probably the most common thing that we do, is literally just explaining things.
Yeah.
And sitting with, you know, victims and really explaining, this is the process, this is what's going to happen next, this is what won't happen, this is why police have told you I don't want to hear about that bit, this is why, you know, they've asked for this is why they've decided that there's not enough evidence to charge, and why that doesn't necessarily mean that they don't believe you that it happened, all of those things. And yeah, I think that, you know, a lawyer liaising with police
is a very different message.
I'm still a woman, so people still think that I'm hysterical sometimes, but it is, it's much easier to kind of get around those, like the need to be emotionless and, you know, strong-willed and whatever. And even just to have the guts to speak up to police. Like, police are scary.
Scary.
I've worked with police for years, and I still find them scary. Every time I talk back to them, I get this like buzz in my body of like, woo!
I just think it's literally absurd that in a case that's meant to revolve around the victim's testimony, or in a process that would collapse without their cooperation, they aren't given like basic information about how to navigate it, what's expected of them, like realistic timelines. I mean, this is why I created With You We Can, and why I advocate so strongly for independent lawyers. But for me, it's commonsensical, because dignity and support should not be add-ons. They're actually preconditions for the system working, because an unsupported victim will disengage. And disengagement means you don't have a case anymore.
A victim who's confused or doesn't understand why you're telling her that she's not allowed to mention that the accused was in prison before they met or something, is a victim who doesn't know how to give good evidence because she's terrified of saying the wrong thing and the whole thing blowing up. There's this really, you know, obviously defence have zero obligations to a victim in a criminal matter. Prosecution, we have a legal system that, you know, when historically speaking, accuseds had no rights, and so it was a horrific system. You had a massive amount of people who hadn't committed crimes being killed for committing crimes. You still see this in a lot of countries where those rights don't exist or they are not upheld properly. An accused should absolutely always have a right to a fair trial and to see the full evidence against him or her or them. But those rights, so when the legal system has grown and has changed, that's been the focus, is on how do we make this, the saying is it's better that 5 guilty people go free than 1 innocent person be put in prison. That's really important. That's really important. That's why, when I was in law school, there was a huge debate around lowering the burden of proof for sex offences to the civil burden of proof. No, we don't want to do that. There are reasons why beyond reasonable doubt is the burden of proof for criminal matters. And that's been the sole focus. So when the entire focus of the legal process is evidence, weighted against the legal rights of the accused, and the victim has no legal rights, then of course the focus of every lawyer in that courtroom is going to be on the rights of the accused. And, prosecutors, they have to be impartial. They have to only prosecute when there's enough evidence to prosecute. They have to uphold the rights of the accused. And they are overworked, undertrained. They are also humans like you and me. They have babies at home and they're not sleeping they are people just like you and I. And they are overrun with the amount of matters that they have. And to me, it makes total sense that the care for the victim and, focus on the victim is, of course, going to be the thing that doesn't exist in that system because it's the only thing that's not legally enforced. And therefore it's the only thing that can go by the wayside.
And so would victim lawyers help prosecutors, do you think?
Yeah. So I think in one way, victims having lawyers, and if we were to go even further and hopefully one day victims having legally enforceable rights, that's going to create more work for a prosecutor. Yeah, that is undeniable. Doesn't mean it shouldn't be done, but that's the fact of the matter. There's more for them to get across. And on the flip side, the prosecutors that I work with who really welcome our service and welcome us in and want to work with us and want to figure out how to work with us, they repeatedly say this went so much smoother than I thought it was going to, particularly because a lot of, at the end of the day, a lot of the clients that we work with are in various different ways particularly vulnerable. A lot of clients with, First Nations clients with disabilities, clients with very extreme PTSD that really impacts their ability to give evidence, clients who experience addiction, sex workers, all of these, particularly vulnerable groups are the people who we're trying to reach the most. You can access our service without being one of those groups, don't worry. But those victims you have to work with them in order to get them to the trial. Yeah. And a lot of, they're not trained in how to do that. They are not trained in how to deal with, they're not trained social workers like we have in our team. But also that it's a lot and it's taxing and it's hard and we can take all of that. So if you have a client who really, you have to communicate to her, we have to drop this charge. We're going to go ahead with this other one, but we cannot go ahead with this one. And that means that at trial, you can't talk about this one. If you have a client who finds that really, really hard to understand and kicks up a fuss, makes it, is contacting you multiple times a week and complaining to your boss or whatever, we're the people who have the time to actually sit and take as much time as it takes us to help the victim actually really understand that decision and hold the emotional response to that decision. And for a prosecutor, that is hours, days, weeks that you can spend on doing the legal work.
So do you feel that independent lawyers, they're beneficial regardless of an outcome for a complainant?
Yeah. We always obviously try and prepare clients for the fact that like getting a conviction in a sex offence matter is very, very rare. But we also really try to prepare clients for the fact that if they get a conviction, it's probably not going to feel the way that they think it's going to feel, and it's not going to suddenly take the pain away.
Yep.
It's not going to change the fact that your family and friends don't believe you or support you. It's not going to change that it happens. It's not going to change your nightmares, all of that stuff. It doesn't make a difference other than the fact that, you know, it can definitely make a difference in some ways. We repeatedly, over and over again, get given the feedback that the only reason that a client was able to make it to trial and actually get on the stand was because we supported them. Or even further than that, we've had multiple people tell us that the only reason that they haven't committed suicide was because of that. And that
One more time for the people in the back.
That outcome is...
It cannot be understated.
It's
literally life or death. Like,
yeah,
it's
is literally life-saving. But from a legal perspective, clients telling us that the only reason I felt able to go and give evidence and get through that trial was because I had you by my side, or had you involved in the matter. Like, legally, we should care about that.
Yep.
Like, societally, we should care about suicidality and self-harm and trauma. But legally, the system should place a massive value on the fact that having a lawyer whose client is the complainant increases their ability to stay in the matter, which therefore obviously increases the chances of getting a conviction.
This has been such a juicy... That's a silly word to use, but it's such a fruitful conversation. Ellie, my last question to you is, throughout your three perspectives that we've covered today, the through line is humanity, a constant feeling that needs to be not just acknowledged and kept in mind, but kept front of mind. Do you think humanity can exist inside an adversarial courtroom or an adversarial system?
I change my mind a lot. I think that I question the usefulness of our legal system in a lot of ways, not just to do with sex matters, but much more broadly than that. And I definitely think that we need to have other options as well as our criminal legal system. And I absolutely deeply believe I could not be a part of the system if I didn't believe that there are real tangible ways to increase the humanity and dignity within the legal system for both parties within the system that we have. And in ways that do not risk the accused's rights.
I always say it, and I said it at the start, you are just a gold mine of knowledge, and not because you're a lawyer, but you are the president of the universe for me.
I'll let my father-in-law know.
Thank you. Pass on my best wishes to Steve. Thank you for talking to me today. And thank you for everything you've shared. I have no doubt that anyone who's listening has something to learn from you. I'm so appreciative, and I know we'll keep chatting. But thank you so much. So much. It means the world to me that you're here.
Thank you so much for having me, and thank you for all the work that you do as well.
If you've listened this far, you already know something most Australians don't. Victim survivors are the only people in sexual offence trials without their own lawyer. That doesn't have to stay true, but justice systems don't change because they quietly evolve. They change because people understand them and demand better. Go to withyouwecan.org to be a part of that demand. This has been What No One Told Us.